The laws that apply to rental properties, especially in the residential space, can be quite overwhelming, and a lot of landlords don't actually know where to start looking and to understand the law themselves. Now, yes, you might not want to approach an attorney every time you have a simple question, although it is advisable. And if you are using estate agents should be trained in all these laws and should be able to give some advice in order to be able to have you as a landlord comply with them. But in summary, let's look at the most important laws that apply in the rental space and particularly in the residential property space. Now, across the board, one has to consider the Constitution. The Constitution underpins every other piece of legislation, every case law, absolutely everything has to be measured against the Constitution. Now, why is that? The Constitution has certain basic rights that every human being in South Africa is entitled to. And all legislation has to adhere to these rights. So when you hear on TV that a piece of legislation has been declared unconstitutional, all that actually means is that once there's been a review over any act that Parliament has allowed to be passed, once the Constitutional Court has reviewed this, maybe they decided that it didn't measure up against the Constitution and thus had to be struck out. So it's very important that we understand the Constitution affords rights to housing, it affords rights to property ownership, but also affords rights to individuals who live in these houses not to be evicted without a court order. So it's very basic. It doesn't go into detail, but it is important to understand that those rights are there and they must be respected. Now, out of the Constitution comes an array of different types of legislation, right? Now, more generally, one would probably look at something like the Consumer Protection Act, right? Now, the Consumer Protection Act applies to all consumers across South Africa. This means that it's not dedicated to residential properties or rentals. What this also means, unfortunately, is it gets a little bit complicated because when you try to apply the rules of the Consumer Protection Act to rental properties, you don't always know what applies and what doesn't. But what we can say is that Section 14 of the CPA does tend to creep up a lot. And what this section speaks about is fixed term lease agreements, right? And that's what property rentals are. It's a lease agreement over a fixed period of time. Now, if it's for a fixed period of time, say 12 months, for example, certain rights are afforded to the tenant in order to allow the tenant to exit this agreement if the tenant wishes to do so. But it also affords the landlord the right to charge a reasonable cancellation penalty if the landlord chooses. So the CPA does speak about notice periods. It requires that the landlord gives sufficient notice, 20 business days, if a tenant happens to be in breach of the agreement. So it does afford the tenants some protection. So it is very, very important to know the CPA and how it applies. But particularly as a landlord, if you want to have a quick read through Section 14, that could really give you some insight into how you need to treat your landlord, why your typical 7-day notice period doesn't apply, and what it means to be required to request a tenant to first remedy their breach before you're actually allowed to cancel the agreement. Now, getting a bit more specific, you look at legislation like the Rental Housing Act. Now, the Rental Housing Act, as it says, it's about rentals, it's about housing, and it's a piece of legislation that governs the relationship between the landlords and tenants. So this is very, very, very specific, and it works hand in hand with the Consumer Protection Act. So you can't ignore one over the other. Now, the Rental Housing Act speaks to the specific rights that the tenants have and specific rights that the landlord has. So things, for example, where the landlord has to provide a written lease agreement if the tenant requests him to do so, that the deposit has to be kept in an interest-bearing account in favor of the tenant, that the deposit has to be returned within a certain period of time after the lease is terminated, that there be inspections, incoming inspections and outgoing inspections. So all the nitty-gritty over rentals in the residential space is covered in the Rental Housing Act. And It's important, obviously, to know this because anything in your lease agreement that doesn't comply with the very specifics of the Rental Housing Act, unfortunately, will not be enforceable. So looking at the Rental Housing Act, it's not a long act. I actually suggest that every landlord read through the Act and familiarize themselves with it, because the Act and the regulations are relatively simple to understand, and landlords need to understand that, unfortunately, they can't draft lease agreements any which way they want. Agents also, I strongly advise, if your lease agreements are outdated, if you haven't looked at them in a couple of years, you have to review them from time to time, because unfortunately there's changes in our law that have to be considered. If your lease agreement doesn't cater for them, it gives the landlord this fake sense of security that they may not actually have. So what other laws do we actually look at? So laws is quite a broad term, because in South Africa, laws doesn't just mean legislation. It can also mean case law. Why? Because case law creates precedent. So when a judge and a court look at certain facts and they make a decision on how to interpret these facts or how the Act applies to these facts, that often creates precedent. And as you go through the court system, the higher the court, the wider the precedent. So Supreme Court of Appeal and Constitutional Court obviously cover the entire of South Africa. Now, case law is also very important. Now, don't worry, landlords. I wouldn't stress too much about the case law, because that does get very, very technical. And that is where the lawyers do step in to try and assist. Just bear in mind that case law does impact how certain legislation is interpreted. So to give you an example, the Consumer Protection Act and how it applies to landlords was relatively recently looked at by the courts. And in those cases, they actually found an example of a case where the Consumer Protection Act didn't apply to a landlord that was renting out the property for income. So these type of examples are things that people need to be aware of, but the lawyers do typically step in to assist with the interpretation of this. Right now, one of the most important ones is the PI Act. Now, the PI Act deals with evictions, right? So it's the Prevention of Illegal Evictions and Unlawful Occupation of Land Act. So we call it PI because the title is quite wordy. And the point of this piece of legislation goes slightly beyond the Rental Housing Act that focuses on lease agreements. PI focuses on any occupation, be it via lease, be it through property hijacking, whatever the case might be, that this person resides on the property. PI is there to protect their illegal eviction. So it's not to protect their occupation. That is not actually correct. The landlord is, as an example, if he has ownership of the property, can apply to court for the eviction of somebody, but the court has to consider certain factors before granting an eviction order. So it's not to protect unlawful occupation, it's just to protect illegal eviction that may infringe somebody else's rights. Now, there is rather other legislation that deals with evictions also. We call it ESTA, but commonly within the bigger cities, we don't often deal with it because it deals with properties, basically rural properties, right? And it has special rules, special notice periods, very similar to PI. And what you as a landlord simply need to understand from both these pieces of legislation is you can't go onto a property, lock the door, and not let somebody back in. There are rules that have to be followed, and that's why this legislation exists. And last but not least, please bear in mind that although it's not law per se, there are tribunals that one can approach, and you'll often find that your tenant threatens you with the Rental Housing Tribunal in terms of the Act, and they are more than entitled to do so. If, for instance, you fail to pay the deposit back, they can go to the tribunal. So do not assume that they have to approach court every time something goes wrong. The tribunal is there to assist both you and them. Both can approach, but because of PI that deals with evictions, you cannot go to the tribunal for an eviction order. That has to be done through our courts. But all in all, those are the most important important laws dealing with residential properties in South Africa and how they apply to you as a landlord.